The Minister has been using coercion to cause people already in Australia for 10 years or more to voluntarily leave. You don't leave, we'll deport you. He's breaking the law. And the third one is imprisonment or other severe deprivation of liberty. This is what the magistrates are doing. They're depriving people of liberty without due process of law. Now, this legislation was introduced by Paul Keating in 1995 and has been on the books ever since. But in 2003, the Liberals gave the International Criminal Court jurisdiction in Australia independently of the Director of Public Bloody Prosecutions, who takes over and discontinues proceedings, independently of every other law enforcement agency in Australia. And we have word that an individual of this court in Europe is extremely concerned about the state of law in Australia, and they have the authority proprio vigore of their own initiative when a complaint is made to them to investigate and prosecute. This is something that should be causing the judiciary in Australia to be very, very careful. They should be starting to get worried, and I have a funny suspicion they are, even though they're still breaking blokes' fingers in the door as they throw you out, you know, next please, next please. But this is what we've put to the Federal Court of Australia in the group proceeding that we delivered to the registry yesterday morning. We handed over the counter and the bloke says, oh, it's not written. It's, sorry, the registrar's away today. Could I get back to you? And he read it, and if you'd like to see it, I can put it up on the screen. What we actually offered to the Federal Court Registrar yesterday morning. This is this one here. Now, there's 7 of us, 7 individuals. They're all pretty well bulletproof. There's myself, there's Lou, Lou's this chap here. The second applicant is applicant. Thank you, I'll correct that. Put an I in there. Jerry, who doesn't care. David Tatana, who's a mad Kiwi. And Tony Bruce Cottle, who's another Kiwi. We've got a couple of Kiwis involved. And there's a fellow called Kelvin William Granger, who I don't know anybody knows him, but there he's around. And the Commonwealth is the first respondent, and the Australian Government solicitors the second. Now, this application is brought by the applicants as representing the United Christian Constitutional Law Group, and the 7 named members represent that group. The group members include 3,500 landowners in Victoria who signed a petition to remove the C48 overlay from their land, imposed by the Government of Victoria, 300 Aboriginal persons who are dealing with a moneylender in Logan and Western Australia, and various other individuals, 150 more in number, who have asked to be included in this group proceeding. The members of the group are all prejudiced by the failure of the first respondent to take over and control the forces to execute and maintain the laws of the Commonwealth as required of it by Section 51 Placidum 6, and to ensure a delegate of the Queen is appointed to every community in Australia in the form of a magistrate under Section 126 Constitution, and to ensure that the common law as required by Section 80 Judiciary Act and evidenced by the word appeal in Section 2 Judiciary Act, where the words court and judge are capitalised, whereas the word court appears 21 times in Chapter 3 Constitution, and the word judges is used in Section 79 Constitution, and no such institute is available to these institutions, available to these group members or any other Australian today. Now, the relief is claimed as a declaration, and the hang on, I'll get this right. Someone said I should buy a mouse, but I've already got a cap, so the mouse doesn't. The questions of law and fact common to the group members are, now, each is a member of the Australian community either as a guest or a subject of Her Majesty Elizabeth II. Each is entitled to the burden and benefit of the Commonwealth of Australia Constitution Act, the Judiciary Act 1903, the Acts Interpretation Act 1901, the Crimes Act 1914, Criminal Code Act 1995, the Evidence Act 1995, Trade Practices Act 1974, and the Australian Securities Investment Commission Act. And when the provisions of those acts are not implied or enforced by the Australian Government Solicitors, Solicitor of the Commonwealth, or the Australian Federal Police are put upon by various oppressive organisations. The State of Victoria is an oppressive organisation, and so are the police in Victoria. Each is entitled to a mandatory injunction. Now, a mandatory injunction is a different injunction to a discretionary one. A mandatory one is one that the statute says basically must be given under the Trade Practices Act or the ASICS Act, and preventing people from willfully disregarding the laws of the Commonwealth when dealing with insurance and banking entities and other authorities. And the applicant claims by way of interlocutory relief a stay on all enforcement and deportation proceedings in respect of each and every group member. So what we're asking for is a blanket injunction. Basically, the big hand of the Commonwealth will fall on the states and prevent them from the time that this is heard from oppressing any one of you, the people, the sheriff from come and taking anything, and basically we're looking to restate the benefits that flowed to you, the people, from the Australian Constitution when it was enacted 100 years ago. That's the essence of what we're looking for. There's all the procedures. The price for filing that is $890. I asked if we could waive the fees because I'm a poor old geriatric fart, but he said no, because there's 7 individuals involved. You'll each have to put in $120, which is not going to worry probably anyone on that list. So we can get the money to file it. There will be no problem with that. The question is, will he file it or not? Yeah. Now the other thing we've got going is we were in the Supreme Court last Thursday and Friday. We had a dog barking for it, which was probably about the same as a little chihuahua.
Not even that.
Calvin was there. Calvin saw our little puppy barking. But
useless bastard. Absolutely dead useless he was.
What was his name?
Well, anyway, he was cheaper than one of.
Old bloody had you.
He was cheaper than one of Ivan's puppies. So there you go. So you can't expect much for that. Anyway, look, he tried hard, but he was pretty bloody pathetic. But you saw earlier the royal prerogative that the Queen cannot be non-suited in any civil or criminal proceeding. The proceeding was brought in the name of the Queen. It was the Queen versus the Commonwealth. I was only the relator. I'm not a person that has to have standing. I was only the relator. I was the informant, the person who's informing the court. So the judge, I don't understand. It might be my fault, but I don't understand. This is true. This is what he did. And our little puppy said, yip, 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 yip. And, but we're going to go and get our money back, and I'll tell you why we're going to get our money back. We were claiming that the Commonwealth owed us $165,000 as the statutory penalty for deceiving a magistrate and being in contempt of the magistrate's court. We didn't get it. But the Trade Practices Act says making a contract containing a cartel provision. The legal profession's a cartel. Even the ABC says that, so it must be right. And so we've got a situation where we can go into the Court of Appeal, they can make the orders we should have got, and they can also say that because it was a cartel,
action, an offence against subsection 1 is punishable on conviction by a fine not exceeding the greater of the following: 10 metres